I did, Judge.
All right, so I have to go through and read this. Did you find anything, Mr. Pinella?
Your Honor, I did find several cases that I could cite to the court regarding, even if it's rebuttal witnesses, this defense is entitled for disclosure under 3.220. I also reread through 3.220, just the standard for what should be disclosed. Again, my understanding is one of the witnesses is a witness the state intends to affirmatively put on at sentencing. The other one's the guy that just showed up and that may offer testimony. To the argument that the state made regarding the second person, the one who just showed up, they were saying that they may put that on as rebuttal to the sentencing memorandum, to which I do have case law to say that rebuttal witnesses should be disclosed. And as far as the first one, the affirmative, I would now rereading the rules, rely on 3.220 under the discovery obligation to disclose affirmative testimony, which the Ms. Jackson certainly is.
Okay, I didn't think the state was calling either one of them, but the issue is that under Rule 3.220 and Booker versus State 634 Southern Section 301, that case says that discovery, a list of witnesses applies to sentencing hearing and the sentencing phase of a capital trial as well as trial. So that was the defense to the prosecutor, but it goes both ways. So I need to read this Chandler case.
It is to be candid with the court. I circled the part that I believe is the relevant argument for the testimony being relevant. The court can take it. It does not discuss when someone shows up for sentencing. I haven't been able to find anything.
Okay.
I would ask for the site that Mr. Pinella, he said he found several cases. Are any of those regarding sentencing? Because I'm finding nothing regarding sentencing. Okay, so what, just for the court to be very clear, you found cases where the state has to supply a witness list for rebuttal witnesses at its sentencing.
No,
Okay.
no, that's why I relied on 3.220 just as a blanket. Yeah.
All right, well, I think Booker answers the question.
Your Honor, if I might inquire, 634 Southern Second what?
301, the 50 CA opinion, and it says that the discovery rules apply to sentencing hearing as well. If there are people, and I understand, and let's just get the timetable, on the table so nobody misunderstands. The defense, and I know that they've been busy, filed a lengthy sentencing memo at 6:29 on Friday night for a sentencing that occurred Monday. I read it over the weekend and absorbed it. They also filed, asked judicial notice to be taken for certain cases for the court to take judicial notice of that. So if the state were asking for a continuance based on the fact that they didn't have time to review all those cases, look up those dispositions, things like that, I would give that to the state. The state did not, I guess, know about at least one of the witnesses until this morning. So it's nobody's fault, but if there is relevant information that needs to be in front of the court for a fair and just sentencing, I need to hear it. But along with that goes the right for everybody to be informed. So if those two witnesses want to testify, and I know, Ms. Thomas, you said something about one of the witnesses, the ex-wife, testifying at some other hearing. That must have been before I came on, because I don't recollect that.
Yes, Judge.
But again, I think that in fairness and to make sure that, that both sides have an opportunity to really delve into whatever's going to be presented to the court for sentencing, that I would grant the defense motion to continue the sentencing if, Ms. Thomas, you want those two witnesses to speak. And I know you weren't putting them on, but if you feel that it's relevant and I need to hear it, then I need to give everybody a continuance to look into it.
Yeah, I agree, and just so the court's inclined to continue the case for him to delve into them, I still don't feel like I have a responsibility to list them as witnesses, especially when I don't know Mr. Germain. Like I said, I've had investigators that are trying to work up a background stuff. I just don't feel comfortable listing him as a witness for the state. I don't know his background, you know, so that's my thing.
I hear what you're saying, but the state's responsibility is not vouching for the witness. So
Okay.
you're not vouching for the witness. The state's responsibility is to, in my mind at least, to list anybody that may have information that's relevant.
Okay,
So, you know, even though I would be hearing from them and not necessarily from you, now that you know them and you feel they're relevant,
yes.
I think that is fine for you to list them.
Okay, so just so I'm clear, I need to list them on a supplemental witness list and turn them over. Do you want to set a time to depose them, or?
That's fine.
Certainly, I'm happy to, yes.
Okay, perfect.
But yes, yes, that's what I would request, a supplemental witness list, so I know who they are.
Okay,
And we can schedule a time, and,
Yeah.
or, you know, not on the record, we can do it right this morning, you and I, or whatever you want to do.
okay, yeah, we can, okay.
So I will grant the defendant's motion to continue the sentencing. And then what I want to do today, though, is also address your motion to have your client sentenced at, in Veterans Court. Go
Thank you.
ahead, sir.
Thank you, Your Honor. Your Honor, on September 7th, I did file a motion, I understand. I didn't email it to your JA, but it is in the court docket. I would ask the court to consider this motion now. This is entitled Defendant's Motion and Application for Transfer of Veterans Treatment Court for Sentencing. I do want to make the court aware, I'm aware that we talked about this previously. The reason I filed this motion is because we, as I recall it, the morning of trial, you brought to our attention that Veterans Court had submitted some kind of notice to you that he was potentially eligible, or I think actually eligible to be sentenced, or for the whole case to be heard in Veterans Court. We looked up Manieri v. State, which talked about in the previous statute, the state did not have the authority to unilaterally deny application to Veterans Court. The state raised, and the court correctly, raised the issue that the Veterans Court statute, or actually diversionary court statutes, had changed to allow the state much greater discretion. And the court ended the inquiry, as I recall it, at that point, once the state objected to the case being transferred to Veterans Court. And we had the trial, and we were all here, now we're here for sentencing. The reason that I filed this motion, though, is because I contend, and I think this is a significant issue, that the procedure for how that entire referral went is unlawful. It's not, it wasn't done correctly according to Florida Statute 394.47891, which actually is the statute that governs Veterans Treatment Court. So, according, and the other issue here, before I continue with my argument, is I have done extensive research on the matter. This issue can be raised after trial and before sentencing. The statute itself specifically prescribes that, and I'll quote, defendant who meets the eligibility requirements under subsection 8 may be admitted to a Veterans Treatment Court program at any stage of a criminal proceeding. And that's 394.47891, subsection 4. And I found case law to back up, and I cited in my motion that a defendant can be sentenced in Veterans Court even after having a trial in regular circuit court. The reason this matters is because the statute tells us what the procedure is. The procedure is this: if a defendant thinks that they are otherwise eligible for Veterans Court, like because they're a veteran and because they don't have prior history and various other issues that the statute prescribes to us, they are to submit an application to the state attorney's office. This isn't, a separate judicial circuit issue or whatever. This is the statutory prescription for how this is done. The circuits are required by statute to establish Veterans Court programs, which this circuit certainly has. I've cited to, and I believe attached Judge Clayton's administrative order talking about why they are relevant. I believe they're important for people exactly in Shane's situation that understand a veteran with significant PTSD, combat-related, 17 years Marine Corps to the Spirit of Iraq, that sort of thing. That's why we have Veterans Courts. And what the statute tells us is once this, even the new statute, Judge, once the application is submitted, an application that this state attorney's office doesn't have, once it's submitted to the state attorney's office, they are to review it for the purpose of determining eligibility. Once that has been done, it has to be in consultation with the court, which has not occurred. So the state, even if they object, still has to determine whether a defendant is going to be referred to Veterans Court in consultation with this court. And respectfully, Your Honor, we haven't done that. In all candor to the court, I didn't understand this issue at the time as well as I do now. You know, I've done a lot of research since, and I see, no, it's not as simple as the state says no, and that's it. It has to be in consultation with the court. As far as the eligibility requirement, and please correct me if I'm wrong, Your Honor, my understanding is Veterans Court here in this circuit is saying several times, they filed another memo in the court memo as well that I cited to you, that he is eligible. And now that he has been found guilty of the third-degree felony of felony battery, even more so, he's eligible for sentencing in Veterans Court. So I respectfully submit that an application must be submitted because the state attorney's office didn't have one. We went and found one from local circuit, I think it was the 13th Judicial Circuit, because they happen to have a readily available application for their Veterans Court program. We've submitted that application to the state attorney's office in an attempt to follow the letter of the law. I haven't obviously heard back on what they're saying about the application that we submitted, but this is the procedure. Once that has been evaluated by the state attorney's office, the state, in consultation with this court, should, or shall, rather, determine his eligibility for Veterans Court. So, because he can be sentenced in Veterans Court, and I respectfully, sincerely submit to you he should, because I believe that's why Veterans Court exists. I know that Mr. Fox here in this circuit has also suggested similar. I believe they're willing and ready to accept him, because he can, even though his trial is held here, correctly, that can happen, and because there's a specific application process and consultation with the court that I would think would and should require maybe input from Veterans Court and perhaps his medical records so the court can evaluate whether it's appropriate or not. That procedure hasn't been followed, and I'm reaffirming my position to please consider transferring the sentence into Veterans Court. Thank you.
All right, Ms. Thomas.
And Judge, we have already had a motion and a hearing on this issue. I think it was a motion in limiting that we discussed this prior to actually starting the trial, where there was one last attempt for the court to make a finding that he could go into Veterans Court over the state's objection. I will pull the digital. Obviously, I wasn't prepared to hear that motion today. However, my recollection of the hearing was that Your Honor relied on case law where there was a higher court that specifically said that the court will not undo the state's decision when finding that someone is not available or eligible for Veterans Court based on the facts and an evaluation of the case. So whether or not Veterans Court is finding him eligible to enter, he would still have to go through the process, and that's their own separate thing. My understanding is why we don't have an application in this county. The other thing is the Mancuso case, I think that I did cite to. Like I said, by recollection, I'll have to pull the digital. However, I know Your Honor made a ruling that you would not enter into Veterans Court over state's objection, but it says, it cites the statute, and it says based on the plain language of the applicable statutes, the state attorney's office approval for the defendant to participate in Veterans Court is required to be eligible to participate. Under the state's applicable statutes, there is to be no judicial second guessing of the state's attorney's withholding of the consent, and that states the Clinton case. So there's plenty of case law. I'm not disagreeing that our Veterans Court operates differently than other outside courts with the statute was applicable. However, my understanding of Your Honor's ruling was, even that aside, this is not a case that you would have considered from the beginning to enter Veterans Court. And I'll pull the digital and I'll file a supplemented memo now that we're handling it today. But I feel comfortable in saying that I've asked the court to abide by your earlier ruling based on the facts of this case, the actions of Mr. Jackson, and us proceeding through trial, with much more facts arising from trial than Your Honor even had at the time she originally denied the Veterans Court motion, and you would once again deny the transfer of this case to Veterans Court.
All right, my earlier decision remains of denying your motion to transfer the veterans court for sentencing. Stay due in order and run it by Mr. Pinella and then my cue.
Yes, ma'am.
All right, so I'm going to leave it to the lawyers to give the sentencing time, but I need you to get together and get with Kathy now to get it. I expect everything to be done timely, and I don't want anything filed sooner than 5 days before the sentencing hearing. Nothing will be accepted by this court if it's not done outside of 5 days prior to the sentencing. So make sure everything's done, and you need to draw it to my attention, filing stuff in the court file. I would never know it was filed. So you got to make sure that I know that it's filed and you want me to look at it. Okay?
Okay.
Yes, sir.
All right, thank you.
Right. Yeah.
All right, no problem.
So I'm happy to get with, I'm happy to work with you now and figure out scheduling. I don't know if you want to